Okay, let's see here. Somebody has asked, this is ID 29137, Law Q&A. How long can you go to jail for a DUI? Detail, I was charged with a DUI and I want to know the punishments I could be facing. Is it for sure that I could end up in jail? Well, the short answer is I need more information. So, there are a couple of different levels of DUI. You're driving under the influence if you blow a .08 or greater within 2 hours of operating a motor vehicle. And if you blew .08 to .14, then you would be looking at mandatory minimums of 1 day in jail and 15 days of electronic home monitoring, and that day in jail can be spent in a thing called detox, which isn't actually jail. If you were over 1.5 or above, then you would be looking at 2 days in jail and 30 days of electronic home monitoring. And so that's with a first offense. Now, if you have prior convictions for driving under the influence within the last 7 years, then the punishment goes up significantly, and you're looking at 30 days in custody on .08 to .14, with another 45 days of electronic home monitoring. So you are actually 60 days in electronic home monitoring, and then it goes up from there. And so depending on what jurisdiction you're in and what your BAC was and the facts of the case, you may not even be convicted of driving under the influence. The majority of cases that we handle resolve in something other than driving under the influence. So they resolve in everything from traffic tickets to negligent drivings, to reckless drivings, and things that aren't DUIs, won't keep you out of Canada. There are license implications, obviously. So first time offense, if you're under a 1.5 and the Department of Licensing finds out that you were driving under the influence, they're going to take your license for 90 days. Now, you're entitled to a hearing, but you only have 20 days from the day that you're arrested to request that hearing. So if you haven't requested it yet, it's been within 20 days of your arrest, you really need to get on the ball and take care of that. The officer should have given you paperwork. If he hasn't given you paperwork, or she didn't give you paperwork, then you need to go to Washington Department of Licensing and go to the driver's license tab and do request a hearing. It'll give you the paperwork. You can fill it out online. You can actually register online or make your request online if you have a credit card or debit card. So that's probably what you're looking at. In addition to those things, your worst case scenario is you're in many cases, the common scenario is you have to get an alcohol evaluation and follow-up. If you lost your license, you would have to get an ignition interlock. So that requires $100 to the Department of Licensing for the ignition interlock license, having the ignition interlock installed in your vehicle, and getting an SR22 high-risk insurance. And that's only if you lost your license. We've had a lot of clients lately in Department of Licensing hearings, and we've been able to keep their licenses for them. You would also be required to take a class called the Victim Impact Panel. You go in and you can find them anywhere from $30 to $75. Some places are more. I'm not aware of anybody that's cheaper than that, at least here in Pierce County. You would also have to get an alcohol evaluation and follow-up treatment, and if the alcohol evaluation said you had an alcohol problem, then they're going to require treatment. That's anywhere from 3 months to a year. What we typically advise people to do is, if you go in and get the evaluation, tell the evaluation people not to release that evaluation to anybody other than you or your lawyer, so that you can take a look at it and you can assess whether or not the evaluation was properly done. If it wasn't properly done, then you have some options. Frequently these people don't get all the information, or they get the wrong information, or they pull information from other cases and combine them with yours, and there are a lot of reasons why. It's just easier if it's released to your attorney or you first, instead of the court, because then the court's wondering what's going on, and it's much more difficult to fix later. So tell the evaluator not to release the results to anybody but you and your defense attorney, at least initially. That's basically it. Again, reckless driving, 30-day license suspension. Even if your license was suspended as a result of a DOL hearing for 90 days, you're still going to get a 30-day suspension, but you can get an intermediate license, and that will let you drive during the 30 days with some restrictions. So there are things that you can do, but get a skilled DUI attorney, and you'd be surprised. You probably won't even end up being convicted of driving under the influence, even if you were absolutely hammered at the time. There are a lot of things that a skilled DUI attorney can do to help you out.